Your Lordship indulgence in making a mention, my lord, of part 2, item number 8, my lord. The criminal appeal, my lord. If this matter may be taken up next week on Tuesday, I have taken the consent of the other parties also. I am for the appellant.
On the submission made by Mr. Suraj Pradhan, learned counsel for the appellant, with the consent of the other side, list this matter in the next week. Any date? You want a fixed date?
My lord, if it possible.
Okay,
on
in the
Tuesday,
next
6
week on,
2/6. Second,
on 6th,
on 2nd of June, my lord.
2nd.
Tuesday.
2nd of June is not a Tuesday. 3rd, on 3/6/2025. Tuesday is 3rd, not 2nd.
Third, on 3rd, my lord. On 3rd or 4th, my lord.
So 3rd,
My lord.
already.
Seeker Lordship indulgence to make a mention of part 2, item number 7.
Yes.
Yes, I have taken the consent of the other party, who are the appellant. If this item may be taken up after 2 weeks,
Okay. Mr.
K. Roland.
K. Rowland, learned counsel for the appellant, has prayed for adjournment of the matter with the consent from the other side. In view of the above list, in the next week. In the next week.
Yes.
For admission, item number 1.
My lord, for newly pleaded respondent number 11, I seek another 2 weeks' time for filing my affidavit, my lord.
How many times have you sought for adjournment? How many times?
2 weeks, my lord.
This is the second or third time?
Maybe third time.
My lord, since the case has been taken up for 9 years
11.
and looking back to the order dated 3rd April 2025, the Honorable Court has directed that directed to file the compliance report positively by the next court date. And after
Have you contacted your client?
No, my lord. In fact, the matter cannot be complied with at this stage. The direction of this court is for to ascertain as to whether the document of the petitioner is genuine or not, relevant or not only. At this stage, my lord, I have, if I may permitted to file my affidavit, my lord.
So have you contacted your client?
Yes, my lord.
You have discussed
Yes,
the
my
matter.
lord. Yes, my lord.
We'll give them a final chance, failing which the appearance of respondent number 11 will be required.
Yes, my lord.
Heard Mr. Ruben Lalrinsanga, learned counsel for the petitioner, along with Ms. Zairim Sangpui, learned counsel for respondent number 11. The learned counsel for respondent number 11 has prayed for another chance,
My lord, if
for,
it is
prayed for
last
further
chance-
time, sort of
3 weeks may be given.
further time to file the show cause reply by submitting that she has it appears from the discussion of the matter with respondent number 11 that you won't be able to comply. Or what?
My lord, it's not a time for compliance. In fact, it's a time for deciding whether the document is relevant or not.
By submitting that the respondent number 11 has yet to verify whether the documents of the petitioners are genuine or not. In view of the above, further 3 weeks' time is given to the learned counsel for respondent number 11 to file the affidavit, failing which the personal appearance of respondent number 11 will be required.
All right.
Yes, list
That's
after
my-
3 weeks.
Item 2.
Your Lordship, in the last court date, I was instructed to submit the affidavit in opposition, my lord, and I'm seeking another 3 weeks' time to submit the affidavit. I was instructed to clarify how they determine the marks obtained by the petitioner, my lord.
We'll give them some more time, isn't it? Mr. Lalpian Felatongtu, learned counsel for the petitioner is present along with Ms. Vanil Siami, learned government advocate for the state respondents.
I'm appearing for the private
And Mr. Steel Alpagzwala, learned counsel for the private respondents number
7 to 24.
7 to 24. The learned government advocate has prayed for further time to file their additional affidavit in terms of this court's order dated 05/05/2025. In view of the above, list after 3 weeks.
3 weeks.
Obliged, my lord.
Obliged.
Item 3.
इसी का किसान देते हैं।
Lordship,
Yes.
I'm appearing on behalf of the respondents 1 to 4, and I have filed
State
my affidavit
respondents.
in opposition.
You have filed.
Yes, my lord.
So where's the counsel for the petitioner?
Counsel for the petitioner is not present today.
None appeared for the petitioner, while Ms. Caroline K. Lulumoipui, learned government advocate, submits that she has filed the affidavit, the counter affidavit. Since the counsel for the petitioner is absent, list after 3 weeks.
Item 4.
Your Lordship, service is not yet completed in respect of respondent number 4. Carrot has not yet returned.
Okay, Mr. K. Rowland, learned counsel for the petitioner is present. It is seen from the office note dated 01/05/2025 that service upon the respondents is not complete till date.
Respondent number 4.
In view of the above, we may
Your
await.
Lordship, if
vote.
I may be allowed to take step by way of justice.
Okay, not yet complete, full stop. The learned counsel for the petitioner has prayed that he may be allowed to serve notice upon the respondents through dusty mode. Praise aloud. The learned counsel for the petitioner to take necessary steps for service of notice to the respondents through dusty mode, and affidavit to that effect is to be filed accordingly. List after 3 weeks.
Obliged.
Item 5 and 6.
Please, Your Lordship, in item number 5, I'll be filing my affidavit tomorrow.
My lord, for respondent number 4, I'm seeking another 3 weeks' time for filing affidavit.
Okay, Mr. Yes,
Alam mo isama man.
appearing on behalf of,
Mr. Jody L. Tauso.
okay, Mr. So-and-so, learned counsel appears on behalf of his senior, Mr. Johnny L. Tauchong. Stop then.
Appearing on behalf of my senior, Samuel Vanashita, who is counsel for respondent number 5 to 8. Same prayer as the above, 2 weeks time to file affidavit in opposition.
Full stop, then, Mrs. Zaram Sangpui, learned counsel for respondents number? 4. Learned CGC, is it? CGC for respondent number 4, along with Ms. Mary L. Kiangte, learned government advocate for respondents number
1, 2, and 9.
1, 2, and 9, and Mr. So-and-so appearing on behalf of his senior, Mr. Samuel Vanlal Shiata, learned counsel for respondents number 5 to 8. have all prayed for the time to file their counter affidavits. In view of the above, list after 3 weeks.
Item 7.
Lord, I am second.
Yes,
The last court date, previous court date, notice was issued. to the
but not
respondents.
returned yet?
Council represented, my lord.
Yes, so you have to file your counter affidavits?
Yes, Your
Second.
Lordship.
Okay, Mr. S. Vanasheta, learned counsel for the petitioner is present, along with Mrs. Zairam Sangpui, learned counsel for respondents number 1, and Ms. Lalun Hlui, learned government advocate for the state respondents number
2, 3, and 4, Your Lordship.
2 to 4.
Yes, Your Lordship.
Full stop. The learned counsels for the respondents have prayed for further time to file their counter affidavit. In view of the above, list after 3 weeks.
Much obliged, Your Lordship.
Highly obliged.
For order. Item number 8.
My lord, I'm
You
appearing
are
on
for respondent
number
number
1,
1.
legal aid counsel, my lord.
None appeared for the appellant, while Mr.
Halal Ramdin Thara.
Dalvin Thara appears on as legal aid counsel for respondent number
1.
1. Since the counsel for the appellant is absent, list the matter after 3 weeks.
Thank you very much.
Item 9.
Lordship, service upon the respondent number 1 and 2 is not yet completed.
This is a MAC appeal. So you can take steps to serve notice through dusty mode.
Lordship, if my
Who are them? Respondents
respondent number
1
1 is the
and
claimant,
2.
and
Who's
2 is-
respond
2
number
is the
1?
owner of the vehicle,
And 1 is?
the claimant, one of the claimant.
So they have to be there.
Yes, Lordship.
You are for 3.
Respondent number 3, my lord.
3 is the insurance
Counter
company?
claimant.
The claimant,
Counter claimant, yes, my lord.
counter claimant.
Yes.
What is this
Seems
counter claimant? What do you mean by clown? There's the claimant. Claimant is who? The wife of the deceased?
The child of the deceased,
Child of the
And-
deceased.
Your Lordship,
And 3 is whom?
the youngest daughter of the deceased.
So is there a dispute between respondent number 1 and 3? Is there any dispute between respondent number 1 and 3?
I'm not sure, my lord.
Then you're one of the claimants.
Yes, my lord.
So now respondent number 1 is a minor or,
Not
Not
minor.
minor,
my lord.
minor.
okay. Then can't you serve notice through dusty mode? What is the address? Let's have a look.
Bloomville. Bloomville.
Lordship, Flungwell,
So respondent number 1 is the daughter,
no, his son,
is the son of the deceased.
yes,
Respondent number 2 is?
owner of the vehicle, and 3 is the youngest, the
Sister.
daughter of the deceased.
So that means respondent number 1 is your brother,
Yes, my lord.
isn't it? So he has not received notice?
It seems so. my
Lordship, the
lord.
facts of the case is that at the time of the accident, there are 2 deceased. One is the mother of the claimants and the niece, and one respondent one claimed for both for both the deceased. And for in case of respondent, the death of the younger, the niece,
Okay.
one and the respondent number 3 come into the picture.
So we can wait for some more time, or you can take steps for service of notice. Fresh steps can be taken, or you can serve notice through Dusty. Which one do you want? Because notice was MACT matters are small matters, isn't it? This was in February. March again, notice not,
Lordship, if I may be allowed to publish,
not newspaper publication.
then by way of Dusty, if Lordship
By
permits.
Dusty, you do it, because there's no assurance that they will read the newspaper. And they're the claimants, respondent number 1. It's important for them to know that what is going on, isn't it?
Lordship.
Mr.
Michael Patrol.
Michael so-and-so, learned counsel for the applicant / appellant is present, along with Miss
Veropari.
Lalropari, learned counsel for respondent number 3. It is seen that service of notice upon respondent number 1 and 2. No, just said it is seen that notice, okay, upon respondent number 1 and 2 is not returned till date. That's done. The learned counsel for the appellant / applicant / appellant is allowed to take steps for service of notice upon respondent number 1 and 2 through Dusty mode. And affidavit to that effect is to be filed accordingly. List after 2 weeks.
Lordship.
List after 2 weeks.
Item
Here also,
Yes, Lordship. Same prayer, however, in this case, as per the last court order dated 1 of May, it can be seen that respondent number 2 has been served notice, but none appear for the respondent number 2. And if notice may be served by way of Dusty to the respondent number 1.
who is to?
Lordship, owner of the vehicle.
Owner. What is the appeal about?
Ma'am, Lordship, same with the previous case.
Regarding the quantum? Or what?
Not the quantum.
What is the appeal about?
Yes,
Supposing the owner doesn't appear, respondent number 1 is the claimant.
Yes, Lordship. 1 and 3.
Okay,
I'm still number 3. I'm still the sister, my lord.
It is an analogous case, Lordship, with the appeals.
okay. Heard Mr. So-and-so, learned counsel for the applicant / appellant. Along with Ms. Lalropari, learned counsel for respondent number 3. It is seen that notice upon respondent number 2 is deemed no, it is seen that AD card upon respondent number 2 was returned as per the office note dated 26/03/2025. No, as per the office note dated 30/04, okay, 2025. In view above, notice is deemed to be complete upon respondent number 2. However, none appeared for respondent number 2. Full stop. Then AD card from respondent number 3 is still awaited. Full stop. The learned counsel for the appellant prayed that he may be allowed to serve notice upon respondent number 3.
1, my lord.
1. Okay. To respondent number 1 through Dusty mode. Praise allowed. The council to take necessary steps for service of notice upon respondent number 1 through Dusty mode, and affidavit to that effect is to be filed accordingly. List after 2 weeks.
Lordship.
Obliged.
Obliged.
Part 2, item number 2.
Lordship, please may I interfere during the proceedings of the court? I have item number 8. But unluckily, when my case is called out, I was staying outside. So please my presence may kindly be reflected.
Which one? Item number?
Item number 8.
You should have been in the court.
Yes.
What did we say in item number 8? Okay, instead of that, okay, make it later, Mr. So-and-so, learned counsel for the appellant made appearance and his presence is therefore noted.
Thank you, Your Lordship.
Lord, my senior, he's having some personal difficulty, so he could not turn up.
What? In which case? What? We have not called out any case. For what?
Part 2, item number 2.
We have called out the matter?
Yes.
Yes.
So if the matter may be taken up tomorrow, my lord.
The matter was listed for today.
Yes, my lord.
What difficulties are you having?
He's taking his son to a hospital due to emergency.
So medical reasons, that we'll have to understand their problem. Mention is made on behalf of Mr.
Zoram sir.
Zoram Thana, learned counsel for the appellant, for adjournment of the matter, since the learned counsel is not able to appear due to some personal difficulty. Mr. S. Valancheta, learned counsel for the respondent is present and has raised no objection. In view of the above, as prayed for, list on tomorrow's date?
Tomorrow, my lord.
No, okay, list on tomorrow's date. Is it okay tomorrow?
My lord.
Yes.
Obliged.
Item 3.
Please, Your Lordship. Your Lordship, this is an appeal preferred by the State of Mizoram against the judgment and order dated 7/4/2021, passed in civil suit number 48 of 2010, wherein the learned trial court has directed the appellant to pay 52 lakhs with interest at 9% per annum with effect from 15/3/2010 until
Let's see the order, judgment impugned. Page,
it starts from say 372 to 390. 3 to 72.
yes.
I'll just go to straight to the relevant portion here. It's
But what,
page
tell me what are the brief facts of the case?
The brief facts of the case is that the government in the department of the PWD department has floated a tender notice, and the successful bidder was Srimati Lal Engmoy, who was initially made a party to the suit.
Okay, Lal
defendant to
Engmoy
the
is a
suit.
successful bidder.
Yes.
Okay.
This Lal Engmoy, Srimati Lal Engmoy, have them subcontract the contract to the present respondent. And the work was supposed to commence. The work was supposed to commence after that, after issuing a letter of notice to the to proceed the work. But then after 24 notice, kind of like a shockers notice, to the contractor, the work was not executed.
Okay,
Now-
in spite of letters of notice.
Yes,
Is it?
24 notice was served. As many as 24 notice was served, but then the work did not commence. And after that, since
Okay, what is the work?
the name of the work is
Under the, which department? PWD?
PWD
So is it some road or something? Road
It's
construction?
upgradation of Mamit to Bhairavi Road.
Ah, again road, that's why we are having these problems.
Yes.
Ah,
I will upgradation of Mamit Bhairavi Road bracket pavement works between 24 to 36
Okay.
kmp.
road, huh?
Group 3. And the estimated amount was 4 crores 58 lakhs 11,910 rupees only. And it was tendered in the year 2006. And as I have submitted before, the defendant number 1 was the successful bidder. And then she was assigned by the defendant number 6 to execute the work on 8/2/2007.
Okay.
And accordingly, performance security was executed by her.
That is the Lengmoi.
Yes, Lal Eng Moi. That she was defendant number 1. And in the year in 8/1/2008, allegedly, the defendant number 1, that is Lal Eng Moi, have signed a subcontracting agreement with the present respondent.
Oh, so La Lengmoi is not made a party in the instant appeal?
Yes. She is not made a party because she was she along with other defendants were struck out as the defendants in the law in
Okay, in
the
the
trial
law
court.
court. Okay.
Yes. And according and in lieu of that, the defendant number 2, the defendant number 2 was paid rupees 20 lakhs. That is Kedeng Luna of Chaltlang Aizol.
Okay, not a respondent here.
Not a respondent here but because of the same reason
Okay.
cited.
Okay.
And the contract work was supposed to start from January 2008.
Okay.
And the agreement so made was between the defendant number 1 and the present respondent, Srimati Lal Eng Moi, defendant number 1 in the suit. But work was due to some reasons cited, whatever reasons best known to the respondent, work was not executed.
Okay, so the work was for how much?
4 crores
4 crores, out of which 20 lakhs was given to another person, defendant number 2, is it?
Your Lordship, that is between them. That is a private dealing between them.
Okay.
It seems that defendant number 2 is the son-in-law of the defendant number 1.
La Lengmoi. Oh.
Yes.
So she had given him also some money.
And according to the, even though it is not on record, accordingly, when the present respondent entered into subcontract with the defendant number one, the defendant, the respondent herein have paid 20 lakhs rupees to the son-in-law of the defendant number one,
So that he can do the work, is it?
so that he can do the work. So that is the private dealings between them.
Okay.
And
But why does defendant number 2 come in picture when the contract was given to defendant number 1, isn't it? And defendant number 1 and the present respondent had an agreement, subcontract. So where does this defendant number 2 come? What is his involvement that he has to be made a defendant? Okay, because who was the plaintiff before the trial court? The respondent?
the respondent.
Okay, because of that, huh? So he has made them the defendants.
Yes, it is admitted that they do not execute the work. But then the case of the respondents before the learned trial court is that they have accumulated or stored some materials, and that they have to be compensated for the materials that is stored for executing the work, even though they did not execute the work.
Anyways, go on. We'll see why you have filed an appeal. When, from what you have said, it's between the defendants, the whole
Yes.
case, huh?
And Your Lordship, the defendant came number 2. The defendant number 2, I'm going to say defendant number 2 because they are not a party anymore. When I say defendant number 2, I'm talking about the
Okay,
civil-
who had
the
received
suit.
20
Yes,
lakhs, huh?
Yes. The defendant number 2 have assured the respondent that every necessary requirement has been complied with and in order. And after that, owing to the persistent pleas of the defendant number 2, the respondent have invested into the contract work. So that is how it came. He came
Okay,
into
so
picture.
respondent started investing, huh?
Yes. So it was basically on the, as per the story, as per the story of the respondent, it is on the persistent pleas of the defendant number 2, who claimed to be a son-in-law of the defendant number 1, that the respondent have invested into the contract work. So accordingly, the defendant number 1 executed a power of attorney dated 5/11/2007,
Okay.
which was allegedly, I'm going to say allegedly because this is in dispute, allegedly accepted and approved by the SEPWD Western Circle on 12/11/2007. Allegedly.
You deny you accepting the
Yes.
power of attorney?
Yes.
Okay.
And
Yes.
accordingly, later on, the respondent and the defendant number 1 has signed an agreement dated 8/1/2008 for subcontracting the work in favor of the plaintiff. So that is after the power of attorney. And the work was supposed to commence and execute from the year 2008, January.
Okay.
And it is the case of the respondent that they have gathered a lot of materials and equipments for use of work for the contract. But due to abnormal and unprecedented rainfall in that year, the work could not be progressed.
Okay. Yes.
And after that, correspondence show cause notice was served by the to the defendant number 1
By the appellants.
by the appellant. And at last, at the worst, this is what happens in the worst case scenario that bid security and performance security should stand forfeited to the government.
What is the amount?
The amount was the bill security. It's 22 lakhs 90,596 rupees
Okay.
only. 22,90,596. This is the performance bank guarantee. And after
So what
that,
did the court say? So then you went to the court, the appellant, respondent number, the respondent, present respondent approached the court. Why did he approach the court?
he approached the court because his claim was to get a compensation for the materials that is stored, materials and equipment that was.
He did not do any work. He did not construct the road.
No,
Then the performance guarantee, which he had deposited, did he
which the
forfeit that?
defendant number 1,
Okay, that was forfeited.
that was forfeited.
Okay, forfeited, so it is the appellant who got. Now then the, okay, so then the respondent approached the trial court for compensation.
Yes, the performance
how much?
guarantee was not in question.
Not
It was
an
the
issue.
matter of issue.
Okay,
The issue was a compensation for damage for storage of
materials, okay.
and
How much? How much did he claim?
he was given the
How much did he claim before the court?
the claim before the court was 56 lakhs,
Lakhs,
56 lakhs,
etc.
Et cetera, yeah.
56 lakhs. Then the trial court,
and also to the defendant number 1, 20 lakhs, different.
okay. So your case now in appeal is because the trial court had made an order that you should pay how much?
56 lakhs,
The 56 lakhs,
56
okay.
lakh with the interest, 52 lakhs, sorry, 52 lakhs, 1,112 rupees to the respondent for the period, for the materials that he allegedly collected in respect of the construction work with effect from 15/3/2010 until realization is made in full. I believe that 15/3/2010 is the date when the suit was filed. I'm not very
Why is
sure.
it 15/3?
15/3/2010. I don't know exactly how this 15/3 comes
So let's see the reasoning of the court, this 15/3. Now let's look at the operative part, now that we know the background.
385 is the relevant portion. Page 385.
385. Yes, so what was the order? Now we can read the order, since we have some knowledge of the background.
Should I read from the issues or?
I don't know, it's up to you. Your
I
case.
think, Your Lordship, if Your Lordship permit me, if I read from the beginning, it would
Okay,
give
okay,
a
fine,
clearer
fine,
picture.
fine, fine.
And this will show as to why the some of the defendants were struck off as the party to the suit. This is a civil suit. I'm starting from page
Yes,
372.
yes.
This is a civil suit instituted by PC Laramthanga, who was substituted by PC Malsomdong Liana against Lal Eng Moyi. The brief facts of the case is Srimati Lal Eng Moyi, defendant number 1, a registered contractor under PWD, had successfully bid the contract works under PWD Mizoram for upgradation of Mamit Bairabi Road pavement works between so-and-so, Route 3. Estimated amount so-and-so, which was advertised on 5/10/2006. The contract work was awarded to defendant number 1 by the SEPWD Western Circle, White letter number dated 8/2/2007. The defendant number 1 executed power of attorney dated 25/11/2007 before first class magistrate Aizol, authorizing the plaintiff to execute the above said contract work in her favor. Before I continue further, Your Worship, the power of attorney dated mentioned here in is not correct, because the power of attorney is dated 5/11/2007. I will come to that, but I don't want.
So just that maybe 2 was added by mistake when it should be 5. Now it's 25. Is
No,
it?
No, Your Lordship, it is not made a mistake. It was not a mistake because it is in the evidence also. I will come to that.
Okay,
but
okay.
I am mentioning this because I don't want the date to be registered in Your Lordship memory.
Okay, so the date makes a lot
Yes,
of
yes.
difference. Okay, so here it says 25. Huh.
Yes.
So you're
Further-
saying this should be 5.
Yes, there is discrepancies on the date. That's it. Further, the plaintiff and the defendant number 1 executed a deed of agreement dated 8/1/2008 before the notary public either for execution of work within so-and-so within the above said contract work. In the agreement, it is stated that the plaintiff paid a sum of rupees 20 lakhs to Sri K. Denghuna, defendant number 3, for the contract work. That the plaintiff may procure machines and materials so that the work could be started within January 2008. As failure to do so may result in cancellation of the contract work, and the plaintiff and the defendant number 1 would jointly take necessary action to procure bills and payments from the PWD with regard to the contract work. The defendant number 6 issued notice via memo number so-and-so in which the above said contract work was rescinded as the contractor was believed to be unable to finish the contract work within the stipulated date and also after extension of time. So they have sought an extension of time. It was approved, but then still they did not complete it. Being aggrieved, the plaintiff filed civil suit number so-and-so and prayed for a decree against defendant number 1 to 3 to pay 20 lakhs along with interest at 9% per annum from November 2007 till final payment is made in full. Your Lordship, before I go further, the defendant number 3 is the father of the defendant number 2.
All family members.
Yes, so that is how the defendant number 3 come into picture. Kedian Huna of Talzang Aizol. So the respondent, defendant number 2 is the son-in-law of the defendant number 1. His name was Sankima, and the defendant number 2, Sankima, is the son of defendant number 3, Kedian Huna. And ultimately, the 20 lakhs was paid by the respondent to respondent number 3. Defendant number 3. So that is how defendant number 3 came into picture. And defendant number 4 to 7, that is the state government authorities to pay rupees 56 lakhs.
So this is the main issue, isn't it?
Yes.
Point number 2.
Yes.
Oh, okay.
And defendant number 9 to pay 22.
Sometimes now this fourth point, declaring respondents. Respondents means defendants maybe. Sometimes the term defendants is used, sometimes respondents.
Yes.
The fourth point,
The
for the
fourth-
respondents, must be defendants.
Yes, maybe this is a clerical mistake. For declaring the defendants as jointly liable to pay damage of 20 lakhs to the plaintiff.
So this is plus the above 20 lakhs.
Yes.
40 lakhs.
And Your Lordship, even though performance guarantee was paid was in letter paid by Srimati Lal Engmoy because she was the contractor. This decree was paid against defendant number 1, that is the SBI, to release the 22 lakhs. That is the performance guarantee that was deposited. So that was the prayer in number 3.
So now the only issue is the second point, isn't it?
Second point.
The rest it's already settled.
Not exactly settled, it was kind of like waived before the learned trial.
Okay, yes, please read.
On 26/8/2015, counsel for the plaintiff submitted an application for substitution of the plaintiff in the name of his son, PC Mal Somdongliana, due to the demise of the plaintiff. The parties were heard and the application for substitution allowed. The substituted plaintiff, through counsel on 9/11/2017, made an application to strike out the names of defendant number 1, 2, 3, 8, and 9 as defendants in the present suit. The same was allowed and the suit is proceeded only against the defendant number 4 to 7 henceforth. As such, the defendant number 1, 2, 3, 8, and 9 are not considered in the suit. And there is no reason here as to why they were struck off as the defendant here. And the records as the records that I have with me did not show any reasons why the whether they have contested or they have just raised no
So made
objection
an
in the matter.
application, because an application was made to strike their names off, so their names
Yes,
have been
but
struck
then
off.
nothing is written that they do not have objection or after hearing the parties, etc. Because the main issue is the parties, the case of the appellant herein is that the contract was between the defendant number 1 and the state.
Anyways, then
Anyway, that is how things was done. And the defendant number 4 to 7 contested the suit, stating that PWD had no knowledge of what transpired between defendant number 1 and the plaintiff, and that there was no contract agreement made between the plaintiff and the PWD. The contract agreement was signed between the defendant number 6 and the defendant number 1, and the defendant number 1 cannot transfer responsibility and accountability as regard to the contract agreement or to any other individual by power of attorney, nor transfer obligations towards them. The main objection in the written statement is that the agreements between plaintiff and the defendant number 1 is without their formal approval as required under their contract agreement. As contended, they were not aware of the subcontracting between the defendants number 1 and the plaintiff. The defendants further submitted they are not liable for any payment since there is no measurable items of completed works. As per the terms of bills of quantity in the contract agreement were completed, and there is no provision for payment of any materials collected separately, that the plaintiff is liable for liquidated damage for failing to complete the contract work within the stipulated time. even though in the agreement there was a provision for the plaintiff to not the plaintiff, the contractor to pay liquidated damage for failing to complete the contract work, but then this was not sought for by the present appellant before the learned trial court somehow.
So now, in view of the arbitration clause,
Yes, there
this
is-
court,
there-
by its order dated so and so, sent back the civil suit to the district judge for necessary orders as per Arbitration Act. So the matter, okay, but the matter was not taken up through arbitration, is it?
Yes, but this is where the whole thing
Yes,
goes wrong.
yes.
When there is an arbitration clause, it is mandatory that
Yes, it should be taken before arbitration.
Yes. But
So however, on so and so, the same was re-endorsed back to this court. So where's the re-endorsement letter? Is it here, apart?
I think it will be in the report, but it is not part of the paper book.
Oh. On what grounds was it re-endorsed for trial? So where's the agreement between the department and the contractor? Where's the arbitration clause there?
I will,
So the matter was never referred to arbitration.
never referred. That
But
is
let
where the
us see
whole,
the agreement clause between the defendant number one and the PW department.
it's page number 63.
63. Okay, just let it be.
This is where the whole trial, it was void ab initio.
63, her arbitration clause, yes. What does it say?
3.1, clause 3.1a, in case of dispute of or difference arising between employer and a domestic contractor relating to any matter arising out of connected this arrangement, such disputes or difference shall be settled in accordance with the Arbitration and Conciliation Act 1996.
Okay, anyway, so I'll leave that, the rest, 3 arbitrators and everything. Now, there must be an order of the district judge giving a reason as to why the matter was not referred to arbitration. Is it because the plaintiff is not a party to the agreement signed here? This agreement must have been signed between the defendant number one.
Defendants number one and the state.
State. So there must be a
The
reason.
order, the order sending back the civil suit was 26/10/2016. The re-endorsement, the remanding back of the
So
endorsement.
find that, it must be somewhere here. This is the, just give it to them. Is it because the plaintiff is not a party to the agreement? To the, this contract? The contract was signed between defendant number one and the PWD, isn't it?
But the sole damage, if at all liable, it has to be paid by the defendant number one. But then somehow defendant number one was struck off as a party. 2016, 2016.
Arrangements or difference shall be settled in accordance with so and so. The agreement consists of 3 arbitrators in case we have to.
Your Lordship, may I read the daily order sheet?
Oh, yes.
Daily order sheet dated 16/11/2015. 16/11/2015. counsels for the plaintiff and the state defendants are present. Heard both sides, and after a perusal of the materials on record, it is agreed that there is indeed an arbitration clause in the matter, and as such, arbitration proceedings has to be initiated in the present case. Therefore, I am referring the instant case to the Honorable District Judge for necessary orders as per the Arbitration Act.
So where's the
And
order
on
the district-
26,
Huh.
it was on 26/10/2016. Nothing is written. It just said case is re-endorsed to P so and so senior civil judge. That's it.
Let's see that. Let me see the order. So both the parties also agree that there's an arbitration court clause the matter. So can we just dispose of this instant appeal
Your Lordship,
on those grounds, setting aside the impugned order
it
and
has to be
refer
because
the
the
matter?
law, the provision of law, the settled provision of law is very clear. When there is an arbitration clause, they have to exhaust that remedy, and they cannot directly.
So instead of lengthy hearing, if the counsel for the other side is also present, and here both of you before the trial court had said that there's an arbitration clause, the matter should have been referred to for arbitration.
If I may, my lord.
So at this stage, we will set aside the judgment and refer it to arbitration.
My lord, as my learned friend has already stated, the contract agreement was not in relation with the present respondent. The present respondent was not a part of the contract. Even his power of attorney, even the power of attorney that was given was denied previously by my learned friend. So what they're saying is that the contract has nothing to do with the answering respondent. So when the contract has nothing to do with me, how can it be referred to arbitration? How can the terms of the contract be applied to me?
But when the contract, it has nothing
yeah,
to
but
do with.
why is PWD liable then? They have nothing
Yes,
to do
yes,
with
exactly.
Yeah, that after she has finished her points, her arguments, then I will start. I have my points, I have my reasons.
Your Lordship, they are somehow tied to the arbitration because it is the case of the respondent that he have the power of attorney, he have the agreement, even though that is denied, that the state have recognized that agreement. And the power of attorney was signed on different dates on the same paper. Some
Where's the
signed-
power of attorney? This is
It's
page. Let's see the power of attorney, and then we'll see the date in which the contract agreement was signed.
I cannot locate just at it is there. Your Lordship, please bear with me a moment because this is the thick file.
Take your time. In the index, it's not noted, the page number?
It's not noted separately.
Yes, power of attorney is at page 114.
Yes, 114. Okay. So if your Lordship kindly come to the last paragraph. This was on the face of the power of attorney executed on 5th day of November. On 5th day of November, it was signed by the advocate 5/11/2007 as well as the first class
It's done
magistrate
on 5th day,
5/11/2007.
yes.
But then the parties have signed on 25/11/2007 each.
And the advocate
And as well
had
as the
signed
first
on
one.
5/11.
So I
Signed
can,
before me on 5/11, 2007, but identified on 25/11, executed on 25/11.
in my decades of practice as a lawyer, what I could clearly say is that the unsigned documents were signed by the advocate as well as the commissioner, whoever the commissioner, and then it was later on signed at home or anywhere. But then that is off the record because it is not on record. What is on record is that in the in the examination in chief, in the cross examination of the the plaintiff, which is in page number 322, he have explained in PW number 2, the 322, sorry, in paragraph number 6. It is a fact that power of attorney is made executed on 5/11/2007. However, I put my signature on 25/4/2008. Now, the date in which he said that is 25/11/2008, but then in the power of attorney, he have signed as 25/11/2007. So this is
25/4.
this is
Anyways,
totally
anyway, you make a submission. So one of your grounds is that since there's an arbitration clause, this matter should have been referred to the arbitrator.
Yes.
Okay, that's one of your points. Then
and
then we can continue.
in the terms of agreement between the contractor and the state respondents is that if there is a subcontracting, it has to be approved by the state. Now they have said that this power of attorney is duly accepted by the the state. Now, if your lordship, if I may take your lordship kind attention to page number 115, this is the alleged documents wherein they have stated that the power of attorney is accepted by the state. Now, it was the case of the state
Page?
appellant,
Page?
115.
115. Okay.
It is the case of the state appellant that
Yes.
this is a manipulated document and reasoning of not
115.
accepting,
Yes.
reasoning of not accepting this, the plea of the state was not given in the impugned judgment and order. We say that, first of all, the SEPWD do not have the power to approve. And second is that this acceptance letter was signed on 12/11/2007. 12/11 of 2007. Now, your lordship, the power of attorney, presuming not but admitting that it was signed, even though in the cross-examination he have stated that he have signed in the year 2008. He have stated that he signed in the year 2008, but then presuming that exact parties.
Yes, 25/11, and this is 12/11.
Yes, 12/11/2007. No reasoning to this effect was given by the impugned judgment and order, by the learned trial court in the impugned judgment and order.
Okay.
Now, this might be an agreement or a power of attorney. They have signed an agreement. They might have an agreement. So, yes, even though he was not, he is a third party to the contract. The respondent is a third party to the contract. If the financial, if the contract was indeed financed as claimed by the respondent, the dispute has to be referred to the arbitration.
Okay,
Because-
because of the contract, huh?
Because of the contract. And the terms of agreement between the appellant and the defendant number one states that if it is a subcontract, it has to be approved by the state.
Okay, is there any provision which says that
Yes, page
subcontract has to
49,
be
49.
approved?
49.
Hmm.
7.1, it's the second last from the bottom.
Hmm.
The contractor may subcontract any portion of work up to a limit specified in the contract data with the prior approval of the engineer, but may not assign the contract without the approval of the employer in writing. Subcontracting does not alter the contractor's obligations. It's very clear. Subcontracting, even though the work may be executed very well or in badly, it never relinquish the contractor's obligations. So this is where the learned trial court have gone wrong, because the defendant number one, that is the contractor, was simply struck off as the respondent. Liability to pay damage could never rest on the state, because they just, I'm not going to use the word simply, but they have collected, they have amassed maybe a huge amount of materials, but then execution of work, if your lordship, if I may take you to the notice, that it starts from page number 121.
So when was the notice given? Contract was supposed to be in 2008, notice was
It was supposed
121.
to commence from January 2008.
8.
After that, they have, anyway, your
So
lordship,
notice was given from October
October 2008.
8.
May I read only
Yes,
this?
yes.
With reference to the agreement cited above, you were given the work and informed to complete the work within 18 months, that is 30/9/2008. However, you were unable to complete the work on time, and even after constant reminder was sent to you to hasten, before this also reminder was sent, you still haven't completed the work till date. And there may be several reasons for the delay. Now you are given an extension for the work till 31/5/2009 as per your request.
31/5, huh?
Yes. I expect you to work tirelessly to complete the work from the date of issue of this letter. If you are unable to complete the work within this extension period, you may not be in a position to counter any action taken against you. For the success of the work, the most important aspects are procurement and storage of GSP and WMM materials, and you are requested to deploy more manpower and machinery equipment. The following are reports of my site inspection on 1/10/2008. While your requirement for GSB material is 9,000 for
Now,
Yes, yes,
1042.
yes,
Oh.
you have only 1,370 cubic meter stored at the site. This is the only work done from year 8 that I have witnessed in the 18 months. I am referring to this letter because this is the materials that they showed. Is 1,370. This is the only work from your end that I have witnessed in the 18 months. So that is from the date of accepting the work till the date of the letter.
So extended up to 31/5,
31/5.
2009. So what happened after that? Any letters after 31/5,
Your Lordship,
2009?
Your Lordship, after that, I'll just, may I
Yes,
take your
yes,
Lordship
yeah.
attention to I'll just flip through the page quickly. 124. After that, they were, the state respondents authorities were conscious, and weekly inspection was given after that. So it starts from page number 124. The letter did not end there, but then I read it till there, because till there, 1,300 something meter cubic was only thing that they have done in the past 18 months. And here, it's nil. It's 1/18/2000. It's still 18/1/2019. It's nil. But then the remarks is that labor camp was constructed on 14/1/2009. Am I going too fast, Your Lordship?
Yeah, it's okay.
Okay.
So now,
Page 125, the weekly report was given on that. And nothing was done in the next page. Nil. And remarks on, as same as before, constructed near their quarry, no initiative was taken other than this. In January, they have constructed the labor camp. And the next 126, it's nil.
So the finally where the contract was cancellation? What is the final order after all the inspection that is done?
Final notice is at page number 143.
Okay, finally 143. This is dated
This is dated
28th May.
28 May 2009.
Time was given till 31st May. So finally on 28th May, a letter was received. A few days before the expiry of the time given to him. That's it.
I think we should go through the letter, the final notice letter here. Your Lordship. May I read? Your Lordship?
28 or 20 or 28?
28.
28. So just a few days before the last date, huh?
Yes, 28.
2009, yes.
Whereas under clause 3 of the aforesaid agreement, the ENC shall have power to take action under one or more subclause so and so in the event of delay or suspension in the execution of the aforesaid work by the contractor, so that in the opinion of the engineer in charge, the contractor will be unable to secure completion of work by the stipulated date of completion and after extension of time, whereas you have delayed the execution of the aforesaid work, and as per the opinion of the undersigned, the ENC you will be unable to secure completion of the work by the stipulated date of completion and after extension of time. And whereas you were served with several show cause notices and instructions mentioned in the reference above, which have not been replied to the satisfaction of the engineer in, it should be chief, by the date specified in the show cause notice and instructions. Therefore, under powers delegated to me under so and so, the in charge,
engineer in
aforesaid
charge.
work under the aforesaid agreement for and on behalf of the government of Mizoram, hereby receives the contract as aforesaid upon the recession bill security performance security stands absolutely forfeit to the government. And you are hereby served with notice to the effect that the work executed is and by you will be measured up on 1/6/2009, for which you are asked to attend the joint measurement, failing which the work will be measured by the department unilaterally in your absence, and result of measurement will be final and will be binding on you. This is without prejudice to government's right to take action under clause so and so to realize government dues and losses, damage whatsoever under such clause and subclause. And ultimately, in the next page, 7th July 2019, the work was retendered. So being aggrieved, the respondent have approached the learned trial court by claiming, by filing a case against the state as well as
For
the-
his equipments, which you had, materials and equipments.
Yes, against the state for the materials that he stored, and against the defendant for the 20 lakhs that he have given, and
okay.
against the SBI for the performance guarantee, etc.
So the court's order.
And
Let's come back to the court's order. The final, the reasoning of the learned trial court as to why the state respondents should give him the
384.
claimed amount.
The
What
reason-
is the reasoning? Must be an issue.
First of all, the amount
Let's,
is
where's
baseless.
the
amount
judgment?
is baseless. It's
Yes.
just taken from the whatever
Whatever
the-
he claimed, okay. So where's the judgment? Let's come back to the judgment.
Shall I
Yes,
continue from where we left off?
No, page, no, we not required, I think we've
Okay,
understood.
okay.
Page what is the judgment? Page 3 something. Now,
Page
at the time of framing of issues, this
issue number 8,
eight,
382.
So let's see the decision in issue number 8.
It is not in dispute.
Wait,
The
where
question,
is
the
issue
question is
number
whether the
8?
defendants number 4 to 7 are liable to pay.
Page what? Issue
382.
number 8, page 382, read that.
Whether the defendants number 4 to 7 are liable to pay 56 lakhs 2,112 rupees to the plaintiff due to cancellation of the work. It is not in dispute that there were some materials were collected and some amount of work done in connection of the contract work. The point of argument is whether any payment is liable to be paid to the plaintiff/contractor. The local commission report of the civil judge Mamit district dated 14/5/2010 recorded the existence of materials collected by the plaintiff. However, the exact quantity of the same were not calculated by the commission as inspection was done almost 2 years after cancellation of the contract work. The findings of the local commission have not been put to questions by the defendant. Your Lordship, before I continue, the facts is very clear. On July 2019, the matter was, the case was, the work was retendered. So another contractor have come into existence, and the question as to whether those materials in the which the commission have reported in 2010 is that of the the previous contractor or the existing contractor at that relevant point of time. So that we have to keep that in mind.
Anyways,
Bill of quantities is defined in clause 1.1 of the conditions of contract as bill of quantities means the priced and completed bills of quantities forming part if the bid. Clause 37 so and so of the conditions of contract deals with bill of quantities and are reproduced below. Clause 37 of bills of quantities. Clause 37.1 bill of quantities shall contain items for constructions, installation and commission work to be done by the contractor. Clause 37.2 the bill of quantities is used to calculate the contract price. The contract shall be paid for the quantity of the work done. For the quantity of work done at the rate in the bill of quantities for each item for work done.
So
That
now-
is as per the contract agreement for work done.
So here, if you look at the issue number 8, come to 382 again, the learned trial court had observed somewhere work done in, yes, collected some amount of work done in connection with the
The
contract work.
Yes, it is noted because I have already taken your lordship kind
Some
attention.
amount of work has been done.
Yes, some amount of work has been done. I haven't taken your lordship, it is in the continuing page of that weekly report. So we
So
did not-
some work has been done, that you admit, isn't it?
Yes.
So the observation of the trial court is that some work has been done in connection with the contract work. So he is claiming some amount for the work which was done by him, is it?
Your lordship, it is very. It is never on the. It is never the case of the state appellant. But then we have acknowledged that some materials were stored. In the weekly report, we will see that.
So
after
the weekly report and the amount claimed by him,
Yes,
they do not, what?
I think that we should go back to the weekly report. Your
Okay.
Lordship, where we left off, and then come back to the issue number 8.
Weekly report starts from page 124.
124. So till page, I have taken your lordship attention till page 128, 126. In 127, new camp, before in January 14, one camp was constructed. That is the only things that they have done for 2 months. And in February 10, 2009, new labor camp has been constructed. Plans are made to occupy the camp by 10 June 2009. And the amount collected is still the same. Now, in the next page,
No, page 1?
1 to 8, they have collected a little bit of GSB. I do not know what is GSB, Your Lordship. But then they have collected some of them, 55. And no huge initiative has been taken this week. Their crusher was repaired again on 7/5/2009, and stones were crushed immediately. So there was little improvement in here. And after that, on 11/5, in page 129, it's more or less the same. In the remarks, it is written, no new improvement was visible. They do not have JCB, but they hired 407 tipper. On 8/4/2009, the vehicles were put on site. As they were unable to pay the hiring charge, 3 of the tippers left the site to go back home. No visible initiative was seen. They do not have JCB, and the stones procured by them were manually crushed by laborers. And in page 130, GSB 24, this is the difference. No development made was visible. They do not have JCB, and the stones procured by them lying on the roadside were crushed manually by the laborers. This is the work done. And Your Lordship, in this week, they did not do much, but in the remarks, it's written new labor camp was constructed and 2 new laborers were hired. No other development is to be seen. And the next page, no, it's nil-nil. No other equipment were procured. They manually crushed their boulders and shift their crushed stones elsewhere. They have 15 laborers, and they plan to take in more equipment. And by in page number 133, the 14 laborers have come down to 4 laborers. across the-
4 laborers.
And in 134, no development made this week. There are no laborers either. 135, materials collected is nil-nil, and the remarks
So
is
no work was
on
done, it appears.
40 first were taken at the work site. Boulders existing in the quarry were taken to the crusher site. They are still no laborers. Boulders stored at quarry were moved to the crusher site, but the stones were not crushed due to absence of labor. And no new materials were collected. In 137, some new materials were collected. Few. Not much was done this week as their crusher was not working. The boulders were manually crushed by the laborers. And this is in the next page is the situation of in picture that it was not done. So they did not do nothing at all.
Okay,
So it is
work
never
done,
the
there's
case
no
of the-
work done.
Yes.
Okay.
It is their case.
Okay,
that they
let's
have
just have a look at the date of the last report, weekly report, the date. The last one, page 137 is dated.
It's dated
2009?
2009.
Something
it's in
5
the month of
2009.
May.
May.
It's in the month of May.
2009.
Maybe 4th May because
This will be the last report done.
the last date mentioned in the column is 3/5. In the signature, it's not really legible.
Okay, fine.
And they have shown it with pictures also. That we can see from the pictures that no work is done.
Okay, let's come back to the
Yes,
judgment.
it is their case that they have done some work and that they finished some stretch of road, but that is not the case of the state, I believe. So we never admit. And I will come back to issue number 8.
383.
383.
Yes.
And the bill of quantity is very clear. Bill should be paid only on work done. Work done at the rate of bill of quantities. Bill of quantity is found mentioned in section 7. Bill of quantities, preamble of the bidding documents of the contract work, page number so and so, wherein it is stated that bill of quantities are estimated and provisional and are given to provide a common basis for bidding. The basis of payment will be the actual quantities of work ordered and carried out as measured by the contractor and verified by the engineer, and valued rates and prices tendered in the bill of quantities where applicable, and otherwise at such rates and prices as the engineer may fix within the terms of the contract. I'm going to come back to this point. The defendant number 4 to 7 have argued that the amount of work done nor the materials collected were not liable for payment as they were not completed items in terms of bills of quantities of the contract agreement. The bill of quantities mentioned in the written object and the positions of the witness of the defendant number 47 is presumed to be the bill of quantities included in the form of bid annexed by the defendant number 1 while applying the contract work, as there is no record of the bill of quantities in the contract of agreement. However, a careful reading of the bidding contract and contract agreements of the contract work did not waiver the liability of the defendant number 4 to 7 to the plaintiff for the work done and materials collected in the contract work. The Honorable Apex Court in so and so, the principle of quantum merit is often applied for some technical reason. A contract is held to be invalid. Under such circumstances, as implied, contract is assumed, by which a person for whom the contract is to be done contracts to pay reasonable for the work done to the person who does the work. The provision of this section are based on the doctrine of quantum of merit, but the provisions of Contract Act admit of a more liberal interpretation. The principle of the section being wider than the principle of quantum of merit. The principle have no application where there is specific agreement in operation. a person who does work or who supplies goods under a contract, if no price is fixed, is entitled to be paid a reasonable sum for his labor and the goods supplied. If the work is outside the contract, the terms of the contract can have no application. The contractor is entitled to be paid a reasonable price for such work as was done by him. It should be taken into consideration that state, being a welfare state, has certain duties and certain norms of behavior when it is associated with individuals. It would not be in the best interest of the state or the government to try and act in such a manner so as to deny rightful payment for work done. This has to be balanced with the concept that the state should not be raided wrongly at the expense of the public exchequer by way of deceit or fraud. The present situation appears to be that the plaintiff had done certain amount of work in respect of the contract but could not proceed as necessary or as stipulated. It certainly did not benefit the plaintiff that the weather worked against him, and for which he was also granted extension, and no mobilization advance was granted to him. And there were also allegations that staff of the PWD were not helpful and that they were demoralized the work force of the plaintiff. Be that as it may, it is a fact that the plaintiff was unable to finish the work within this stipulated time. It is also a fact that the plaintiff did some work and collected materials for the purpose of the contract, and that he has not been paid any money for his work and efforts till date by the defendant due to the fact that he was unable to complete any item of the work as per the bills of quantities. Therefore, the present issue is decided in favor of the plaintiff. Now, Your Lordship, first of all, the bill of quantities have clearly stated that bill of quantity shall be paid for the work done.
Yes.
Now, I have taken Your Lordship to the exhibited documents before the learned trial court, and all these exhibited documents is admitted in the examination also before the learned trial court in the evidence. And then wherein it is clearly, it's written in black and white that they have collected few materials. He have collected have few materials, but then it is not work done, so it cannot be calculated, it cannot be inferred, or it can not be presumed to be included in the bill of quantities. They have entered in the contract. The contract is valid between the defendant number one and the state. The bill of quantity is very clear. It should be paid as per the work done. Now, the learned trial court have cited the authority in page number 384. It starts from third
So,
line.
yes, we just read, isn't it?
Yes,
We just
the
read that.
principle has no application where there is specific agreement in operation. So this case, the authority relied upon cannot be used against the state,
Okay.
because the principle have no application when there is specific agreement in operation. There is specific contract, specific clause of agreement in this.
So you're saying it's not between, it's not with you, but it's with the defendant number one.
It's with defendant number one. It's not applicable to the state in as much as the state is not liable to for the whatever transpired between the defendant number one and the respondent.
Yes.
And on presumption, on based of presumption and the calculation, the amount, the amount 56 lakhs is just as claimed. When there is a contract work, it has to be measured. It has to be verified by the measured by the authorities, by the parties
But the
included.
trial court had mentioned something about the commissioner,
No, it's just
appointment.
for
The local
inspection.
commission report.
Yes, it's just for inspection. Yes.
Where's that?
was
Where's
in
that?
2010. I did not find in the paper book, Your Lordship.
Okay, where's the records of the trial court? I'll give it to her, see if it's there.
recognize the amount, if it's going to be paid from the exchequer of the
Should
public.
not be paid from the exchequer of the state, you're saying that. But let's see
Yes.
the local, this thing, commission report. Well, that should be made a part of the paper book. Isn't it, if it's not in the paper book, when the judgment refers to that?
Okay, okay. 5/10/2010.
Okay, but here the exact quantity of the same was not calculated, but
As-
what is it? What is it? What does the report say? So when the
14.
plaintiff had filed his plaint, has he explained how the amount is calculated? Or we'll leave it for the respondent to explain the amount, maybe.
All the parties except the defendant present today is fixed or so and so. Nothing. It is not taken in record, it seems. Because it
It's
is
not
not
in
written
the
in the
trial
order.
court's report.
The report is dated 14/5/2010, but 14/5/2010, after this, it's just written 17/5/2010. It's just written, all the parties except the defendant number 3 are present. Today is fixed for WS. However, court is adjourned as agreed by the parties. In next case, court is adjourned. In next case, fixed for WS. However, court is adjourned.
So during the evidence, when the evidence was adduced, was this report exhibited in the court by any of the
No,
witnesses?
Your Lordship, that is why it is not mentioned in the.
Okay, it's
judgment
not an
also.
exhibit.
It was just it comes out of nowhere.
Anyway, we'll leave it for the respondent to explain as to how he calculated the said amount.
Judgment in order. Proposed issues. Airship certificate. For document. Order. No.
Yes, since the appeal is against this judgment, we have to scrutinize the judgment and see what is wrong with it.
CM 63 of 2010. CM.
No.
Civil misapplication.
Just a show, give it to him, the whole thing, let him see if it's there, or everything, all the documents that were received from the whole court. So the findings of the local commission had not been put to question by the defendants. That's the observation of the learned trial court, the findings. So we have to see what is the finding.
My learned friend have a copy, but
I
then
have
it
a
was-
copy, my lord.
It was not
But how do you
executed.
have the copy? You had filed it before the court? How do you have the copy? Did you give a copy to the court? When was it given? Was it exhibited in the court? But is it in the absence or without the knowledge of the defendants then?
No, my lord.
My lord, I don't see the order for constituting the
As you
local
can see, my
commission
lord,
also.
a separate CM application was made.
Okay, so where's the CM application? It's not here.
That's what I'm trying to find out.
Then we'll have to call for that. Then we can continue the hearing in the next day. It's not there. CM application number what?
63 of 2000. CM number 63 of 2010.
It's not here.
I'm not finding.
Then
the
we'll
file.
have to call for those records. See, because we'll have to see whether this amount, 59 lakhs, made, mentioned by the trial
56
court, and whether, yes, 56 lakhs is to be paid by the
It's just
appellant or not. So if the appellants are said to pay the 56 or whatever
No,
lakhs,
nothing
then
is
we have to
mentioned.
see
It's
how,
just that, it's just reiteration of what the respondent is saying, that PC Lararamthang has said that he used to have so and so.
May I read the report, my lord?
Okay,
Yeah,
well,
but
it
let
is
it is
your
not
turn.
executed.
It's not really important in your submissions, is it?
Your Lordship, it's kind of, I cannot.
Okay, we'll leave it for the respondent to explain how he had calculated that amount. And at that time, maybe if this is required, we'll call for it. Isn't it? Yes, yes, please continue.
And in that report also, I have just gone through, in just 3 people who have known the work that is done by PC Lararamthanga, that some were scattered and then some were still lying. And then it's just from the statement made by PC Lararamthanga that is the respondent.
Okay,
And there is no direction or suggestion to.
the amount. Oh, okay, fine.
And Your Lordship.
So you're going to say that
presuming-
relied wrongly on the report?
Yes.
Oh.
It was, first of all, it was not exhibited.
On a
exhibited.
report which is not comprehensive and not exhibited?
Yes, and it is based on, the report is based on the statement made by the respondent. And presuming but not admitting that, presuming but not admitting that the the state is liable to pay for damages or compensation to the respondent. The same has to be measured and certified or verified by, as per the relevant rules that is used by the PWD.
Where's that?
It should not be. It is there in the bill of quantity, it's written.
Where?
In the second paragraph,
Of what?
second paragraph of the same page, 382. Issue
382?
number, yes. This is just extraction of the conditions of contract. I'll just read from second last line. Clause 37.1, bills of quantities shall contain items for the construction, installation, and commission work to be done by the contractor. 372, the bill of quantities is used to calculate the contract price. The contract shall be paid for the quantity of work done in the bill of quantities for each item. And in the next paragraph, bill of quantity is found mentioned in section 7, bill of quantities preamble of bidding documents for the work contract, page 72 to 74, wherein it is stated in point 2, bill of quantities are estimated and provisional.
So where did he take all that? Bill of quantities was produced before the court or what? This court,
Your
where did he
Lordship,
quote all this?
Your Lordship, this technical thing,
Oh.
as much as I understand to my limited knowledge in the
Section
field.
7, where is this section 7? Where? What is it?
Yes,
Something-
this is extraction, so I'm just taking it here. The basis of payment will be actual quantities of work order. The bill of payment will
So
be
it's
the
actually,
actual quantities of work
so
ordered
actual
and carried
quantity of
out.
work done. So it emphasizes on the work done, isn't
Yes.
it?
As measured by the contractor, and verified by the engineer and valued at rates and price standard in the bill of quantities. First of all, bill of quantities is not submitted to the items that is stored. Second is that it has to be verified, and it has to be verified. It has to be measured by the contractor, verified by the engineer at the valued rates and price of the bills of quantities. So presuming but not admitting that the state is liable to pay, it has to be based on reasonable price as per the value of the rates, that is as per the agreement.
So the trial court has quoted all this,
He has quoted all this, but then without any
not
reason,
applying this.
not applying this.
Okay.
He's just, the Learned
Yes.
Trial Court is just taking the quantum of amount for compensation. First of all, bill of quantities was not presented.
Okay, fine.
It is based on, nothing was based upon. And the my fourth ground is that agreement, when a person has entered into a contract, an agreement have to be taken into effect, and it is the duty of the Learned Trial Court to give effect to the agreement. Now, without giving effect to the agreement, the Learned Trial Court have simply, I have just seen the application for striking of the applicant. It's very casual, in a very casual manner. They have
Okay,
just,
now is the copy of the agreement between defendant number 1 and the respondent available in the,
that agreement 8/1/2008.
the agreement between defendant number 1 and the respondent?
It's
This thing is, since there's agreement between defendant number 1 and respondent, that should be given effect, isn't it?
I will check.
In the paper book.
It is there in the paper book. Your Lordship. Just turn to the page. It's page number 116. It's just translation copy is there in the paper book. I do not have the original copy.
Agreement between Laleng Moi and the present respondent.
Yes.
Okay. This is invoice. So in the agreement, next page, 117, is the appellant anywhere mentioned here? Their presence, this thing, did you sign anywhere? Nothing. Okay. Let's, you just read through this thing. Terms of the agreement, what did they agree? You're saying that should be given, this agreement should have been given effect,
Yes,
isn't it?
it
Let's
should
see
be
the
given
agreement.
effect.
What is the terms?
The terms is that, point number one, Mrs. So-and-so is assigned to contract work, namely so-and-so, for amount of so-and-so. Mr. Respondent of JVM will perform the subcontract work from this contract. The bill of money will be sold after by him and Mrs. So-and-so together at PWD department. For this contract work, so-and-so already paid fully to defendant number
Yes.
3 on 4/11/2000.
Simply gave to Mr. another person, isn't
Yes,
it?
yes, simply gave. The
Anyway,
estimated cost of work would be so and so.
1 crore.
Yes.
And the amount,
Almost-
estimated amount is
Yes.
4
almost 2
crores.
crore, yes. And another 2 crores, I believe that is the profit. I don't know. Regarding how the work should be performed, it is agreed that during the month of January 2008, equipment and other machineries should be procured as the contract is liable for cancellation. The work not started during the work. The work is to be started without fail. If the work is not started, the subcontract may also be cancelled. First of all. Moreover, so-and-so assigned to so-and-so is to be started with the month of January 2008. We have both agreed that if contract was cancelled by chance on account of fault of either one of us, we have agreed not to argue the matter. The explosive and bitumen requirement at so-and-so may be obtained by so-and-so by means of indent, and he will be assisted by so-and-so. The money will, however, be borne by so-and-so. The agreement was made according to the will of both parties to rightfully declare that no coercion were involved, and we thus sign our name below. So it was agreed that the respondent will finance the matter, and then they will pursue the bill together to the state. But that they did not do because they did not make any work.
Yes,
And they
okay.
were very well aware of the fact that if they do not do the work, then it's liable to be cancelled.
Anything else?
Yes, and I hope your lordship have gone through the application for striking off the names of the defendant about so and so. It's very casual, and then casually it was allowed with no reason. I don't think that I don't think that objection was invited in the matter also, because nothing is written. It was not submitted as the CMA, nothing as such. It's like a casual leave application to the office in charge.
1, 2, 3.
1, 2, 3, and 9.
Who's 9?
SBI.
Okay.
Agreement has to be given effect.
Yes.
Now, the impugned judgment in order is baseless, and then it is only, and the learned trial court is trying to let the state respondent pay the damage through the public exchequer without any basis, only on the implied statement that the state, being a welfare state, have some duties.
Okay.
So I will go back. First of all, my first ground was that government do not have direct contract with the respondent, and that we are not liable of whatever was transpired between them. Second is that when there is arbitration clause, it is a settled principle of law that the court do not have any jurisdiction. Third is that no calculation was made as per the contract and not as per the relevant rates or as per law, and it was totally baseless. Fourth is that agreement have to be, an agreement between the parties have to be given effect. The agreement, the contract agreement between the parties, the defendant number one and the state, as well as the defendant number one and the respondent, has to be given effect. And the fifth is that this is without any reason. This is without any reason, just because the state being a welfare state, do not have the liability to pay the damage to the respondent for no work was done for the state by the respondent.
Yes.
With that, I finish my argument. And Your Lordship, with regards to the arbitration and the calculation that calculation, it has to be based on some reasonable calculation, etc. I have citation which I do not have.
Why
today.
don't you have it with you today, when you know it's going to be heard today?
Your Lordship, I kind of misplaced the file yesterday. We were totally searching the file, so.
Okay, you can give me your authority later with a copy to the, at least a citation to the other party. Yes.
May it please your Lordship. My Lord, firstly, with regard to the calculation of the amount collected and whatever, I would like to state first off that the state has never questioned nor even made an objection to the amount that has been claimed. Their objection has been that, firstly, I have done no work. Secondly, that I may have. Firstly, I have done nothing. I have done nothing.
Okay, no work done.
Secondly, then they stated that I may have leveled some road for my own personal use. And for that, the government has no liability.
Okay.
And then the third objection with regard to that they have made is that the work that I have done, they cannot be paid because they are not completed works as per the contract. So those are the objections that they have raised with regard to the amount or whatever in the trial court. Now, hereafter, firstly, I would like to start up with regard to the performance bank guarantee, which has been brought up by my learned friend. Now, the performance bank guarantee, it was issued by the State Bank dated 27/7/2007, issued by the Field Officer, Personal Banking Division, State Bank of India, for which the contract was first accepted by the state. My lord. Now, I was induced into this matter, performing that it was a valid contract, that whereby performance bank guarantee has been duly and properly submitted and verified. However, my lord, after proceeding with the matter, after proceeding with the contract and starting the work and doing whatever I could, I applied for a mobilization advance, which was not allowed. And thereafter, because of the excessive weather, work could not be done properly. It could not progress smoothly, which can be proven because of the extension of time which was allowed by the state respondents. And then thereafter, when the work started going a little bit more smoothly, at the work site, gossip started. All this gossip started, stating that the contract was going to be cancelled because there was no genuine performance bank guarantee that had been given. It is a fake, and because of that, the contract is going to be cancelled. And then thereafter,
Work site, there was some gossip, is it?
yes, because the workers were being told these matters by the people, the people of the respondents, the appellants, who told our laborers and workers that to stop working because the contract is going to be cancelled anyway. So because of that, we are facing a lot of problems with our labor. Now, due to that, I had made an application to the State Bank of India, and it was made a part of the plaint also, my lord. Annexion number 10 of the plaint, copy of the letter dated 28/3/2009.
Page?
Let me get to that point. It's a
Paper
very
book?
thick document, so the pages are a little bit haphazard. Annexion number 8. Annexion number 10. Just bear with me, my lord. Kindly bear with me. 1 second. Page number 142, my lord. May I read, my lord?
Wait, let me turn page 142.
Please refer.
Yes.
Please refer to your letter number NIL dated 25/3/2009. In this connection, we have to inform you that we have verified our books and accounts and found that the security amount rupees 22 lakhs 90 something against the said performance bank guarantee does not appear to have been deposited by Srila Lengmoi into the bank on 27/2/2007. Further, we like to inform you that the performance bank guarantee, which was issued in favor of the Chief Engineer PWD Aizawl by one of our field officer, PBD, is also not recorded in our books.
So what does this mean?
Pardon, madam?
So what does this mean? Further, we'd like to inform that which was
That means the
issued-
performance bank guarantee was fake.
So performance ban guarantee, it has to be done by Laleng Moi, defendant
The
number
Lengmoi
1.
defendant. Submitted to the
So the one who is at fault is defendant number 1, Laleng Moi, isn't
Yes,
it here?
Yes, yes.
Huh.
But that being the case, and this letter by the State Bank that was given to us on 28/3/2009, just 2 months before the matter was cancelled. The
28/3, okay. Oh.
Now, I would also like to take you to page number 144. You had already been, you have already gone through
Yes.
with the appellant. In
144.
Page 144.
We have not gone through this.
Yes, you have.
144.
This is the final. This is the final.
145.
144.
144. Okay, okay. This final letter, huh?
Final letter.
The end
Now the
part.
second line. I, Engineer Lal Dela Silo, the engineer in charge should be in chief for the aforesaid work under the aforesaid agreement and on behalf of the government of Mizoram hereby rescind the contract as aforesaid, upon which rescission, bid security and performance security stands absolutely forfeited to the government, and you are also hereby served with notice to the effect that the work executed, if any by you, will be measured upon up on 162 for which you were asked to attend for joint measurement, failing which the work will be measured unitarily in your absence, and the result of measurement will be final and will be binding upon you, so and so. Now, here the government is saying that they have rescinded the contract and the performance bank guarantee of rupees 22 lakhs has been forfeited to the government. That means the government have taken the money. Now the State Bank is saying that no money has been deposited. How can the government take the money when no money has been deposited? And here at page number 166, which is
So
the
then
annexure number
you
1.
should sue the State Bank's letter.
No, actually, my lord, with this in this regard, I'm not trying to trying to talk about my cause of action.
Because this letter is addressed to Lal Eng Moi.
My lord.
Okay. So the state government will presume naturally that she must have given the performance guarantee. And
Kindly
then
bear with me.
then they can check later whether this was there or not.
Kindly bear with me, lordship, because I'm bringing up this point just to show, just to familiarize your lordship with the attitude that the government is having towards me, the plaintiff, and how I've been treated. This only goes to show a little bit of the bias that I have been dealt with.
Your name is also not here.
Pardon, my lord.
The government has not addressed you. They have addressed Lal Eng
I will
Moi,
get to
who's
that,
the
my lord. I will get to
contractor.
that. I will get to that. And in continuation of the previous point, my lord, I would like to take your lordship to page number 166. This is another letter issued by the State Bank of India, which is a part of the annexure of the state respondent, my lord.
Exhibit as Exhibit D1.
Exhibit D1A.
It was exhibited by whom?
It was exhibited by the state.
State exhibit, okay.
With reference to your letter number cited above, I have the honor to report that the bank guarantee number 00AA 0744650 for performance security in favor of Sri
Is genuine.
is genuine and issued by us, signed field officer of Personal Banking Division, State Bank of India, Aizawl branch. So, and they have submitted along in their written statement. Now, I would like to take your lordship to page number 297. This is the written statement of the State Bank of India. I would like to take you to para number 8, page 297.
Yes.
The statements made in para number 2 of the plaint that the answering defendant issued performance bank guarantee dated 27/7/2007, 27/2/2007 is categorically denied. The alleged performance bank guarantee is fictitious and is not issued as per the bank's norms and forms. Moreover, the field officer, Personal Banking Division, SBI Aizawl branch, Aizawl, who allegedly issued the said performance bank guarantee, have no authority to issue such performance bank guarantee.
So Lal Eng Moi did not deposit the amount, is it?
No.
So?
So it seems she had not deposited the amount, and the government is saying that we have taken that amount.
Oh, they will naturally.
But so that means there was something going on between the defendant and the state. It is an indication, my lord, which we cannot prove, but it can be implied from that alone. And thereafter, my lord, with regard to the subcontracting, I have no objection to what my learned friend has already said. I am, even though I am not well aware of the, I'm not a contractor. And prior to that, there was a lot of buying of contracts. People have, it has always continued. So owing to my ignorance, I had signed those things, and even though a subcontract was duly executed between the defendant number 1 and me, it was never approved by the state in writing. Yes, of course. And however, with regard to the Power of attorney. I would like to take your lordship.
Okay, you take us to the power of attorney, then we'll break for lunch. We'll continue at 2.
Okay.
Yes, power of attorney, page.
Uh,
It was page what? Somewhere we had looked at it.
I had made a group on the.
It's in the index. Where's the power of attorney? Should
No,
be
it's
there.
not. No, it's not particularly quoted on the index. 114.
Power of attorney is 114.
Okay, page 115.
115, yes. 114 is the first page, 115 is the second page, yes.
115 is the
Power of attorney.
acceptance of the power of attorney by the SE PWD Western Circle.
Where?
Pardon, madam?
114 is the power of attorney.
115 is the acceptance. of the power.
Acceptance, so
So, after it was duly accepted by the state, we believed that we were the subcontractors, we were the owners, the new owners of the contract. That was our belief during that time.
so you
with
signed
regard-
it after it was accepted.
Pardon, madam?
You signed on the power of attorney after it was accepted, is it?
My lord, the dates on that, with regard to that,
Power
there
of
was some,
attorney?
there was
It
some,
was signed on 25/11/07
my lord,
by both of you,
my
25/11.
lord. Because, as has already been stated, I am not,
Because you were illiterate. Okay, fine. Anyway,
no.
we'll stop for this thing. We'll break for lunch.
My lord.
We'll meet again at 2.